Hey everyone, we're just waiting for Lisa to join us. Thank you so much for joining. Really appreciate you guys being on board here. Lisa has been invited, so she's going to be coming on soon. Hey Lisa. Hello.
Hi.
Hey Lisa, how are you doing? I just wanted to answer one of our followers. Yes, we will save this video for later so people can always tune in and watch the video when convenient for them. Lisa, how are you doing?
I'm well. I'm well.
It's so good to see you. I know that the last live was with Ariana, so I've missed our interactions, but really looking forward to this one. I'm just going to give a brief introduction. My name is Daniel Marsh. I'm the director of Marsh Fidelity. We are a fiduciary specialist business in KwaZulu-Natal. Ariana is a valued team member of ours, recently admitted attorney, so congratulations to Ariana. There's a lot of hard work that goes into that admission, so we're really proud of her. And Lisa is the law mom, not only of KZN, but of South Africa. She's done incredible work in terms of providing advice and really building confidence in young professionals, which is so important. So Lisa, thank you so much for all the work that you do. As a side note, she's also a criminal defense advocate, which is also something in itself. So Lisa, we're really grateful for this journey that we're going on. And like I said, we've been having emails of support from people all over South Africa. We got an email last week from someone in the Free State to say they're looking forward to this live. And I know that from your work, you've reached people all over, outside of South Africa as well, hey, Lisa?
Yeah. That alone is so encouraging. Just to you're just doing your thing, We're getting on a live, or I'm making content, but yeah, I'm always, I guess, I've been, been made aware of those invisible, even those that don't say anything, right?
Yes.
Like somebody is getting impacted. So the fact that you can reach across provinces, borders, national borders, I mean, it's fantastic. It's so satisfying.
Yeah, and you know what's really cool as well is that it's like we're creating a live journal because we talking about stuff in today's right now, about stuff that has happened and how we can help families and all of that in the States. And a lot of the actual literature is quite old in terms of estates and wills and in some cases law. So I think today our discussion is going to be very nice because it's based on court cases that have actually been ruled on. And then we can look back and say, this is what happened in each case. This is what we would advise would be best to go forward. And then also just discuss our points of view on it. So I just wanted to run through. I'm going to be talking about a court case with regards to a condition set in a will. Ariana is going to be chatting about a court case on where you actually sign your will and how it can have an impact on if that will is accepted or not and what the ruling is on that nowadays. And your one's also very cool, Lisa. Your one is basically the interpretation of a will. And sometimes if you don't put something in full in there, how the court can have power to interpret what you could have actually been intending. So I look forward to that discussion. Guys, we're also having a little giveaway. You have to watch till the end of the live. Once we load the video, we know people can fast forward. That's acceptable. But we're going to let you know what you need to do to enter to win 2 of our family remembrance books, which is an idea that I basically came up with in terms of how important written words are when you've lost someone. So if you have written words from your mom or your dad or your gran, it actually brings them to life in that moment. And I had a moving experience with that, and it really helped me. So that's where the book is from, and that will be a gift at the end of this live. Cool, Lisa. So I'm going to start on my case. My case is an interesting one. Basically, a condition was set in a will. So the testator, who's the person who died and who signed the will, owned 2 farm properties. In his will, he bequeathed both farm properties to a surviving spouse, but on the condition that if she ever decides to sell these farms, there will be a set price that he put in his will that can be offered to his daughter's husband, so his son-in-law, to purchase at that price if she sells whilst she's alive. But it also added that if she doesn't sell while she's alive and she dies, he has the first option now to purchase that farm from the estate at that price. Okay, so now the issue was that this clause didn't have a lot of flexibility in it. So it basically said, this is the price, even if it's 20 years' time and you want to sell, you have to sell at that price. So now if you're thinking about market changes, inflation, this is in South Africa, the rand fluctuates, none of that was put in the clause. So there were other kids involved. And what happened was the mom did sell one of the farms while she was alive, which was fine. But she died without selling the second farm. So now when the estate is being administered, the executrix has to step into the role now of the deceased, which was the surviving spouse. The son-in-law comes to the executrix and says, listen, I have a right here to purchase this at 176,000 Rand, which is what is stated in the will. The property at current market value is 5.2 million. Okay. So now the other siblings are looking at it and saying, listen, I thought that I was going to get a share of 5.2 million. You're now saying I'm only going to get a share of 176,000 Rand. That's unfair. Okay. So the other siblings, now led by one of the daughters, took this to court. Now the tricky part is remember, you've lost someone that you love. Now you've lost both your parents. But because of the way that you wrote your will, all your kids are fighting. And it's the last thing that this guy probably wanted. But he didn't have proper advice. So he just said, guys, this is the price. He didn't put any substitute condition, which I'll touch on towards the end of this, to say, like, with conditions, you have to really look at the whole picture and you have to have professional advice, especially with farming land. So because of this inflexibility, the daughter said, listen, the farm's worth 5.2. You're going to get it for 176,000. That's unfair. I'm taking it to court. So they went to the High Court in Kimberley. And basically the argument was that the daughter said that both parties had to sign this condition because of a section in the Alienation of Lands Act that says that both parties, there's certain requirements that need to be met, and one of them was that both parties didn't sign. Okay, so the High Court in Kimberley actually said, okay, that's valid. We'll accept your argument. Then the Supreme Court came and said, listen, that argument is fundamentally flawed because it's a testamentary disposition. And the person who wrote the will just basically said you have a personal right to either, look, you don't even have to buy, he set a price, okay? So he could have actually said, I don't have money. I don't have the 176,000 Rand. I don't want it. It doesn't force anyone to purchase. But the fact that he gave him a personal right to say, hey, listen, you can purchase this property, this farm, for 176,000. He didn't say in 12 years, in 20 years. He just said, if my wife ever decides to sell or if she dies, you have the first right. So when she died, he said, hey, I'm going to exercise my right now. And what happened was the Supreme Court overruled it and actually said, yes, you can buy this property for 176,000 Rand, even though it's worth 5.2 million, because the testator put that as his wish. So you see, Lisa, the power of our words, especially in a will. This is years after he's gone. And now a massive fight has come out when the surviving spouse has died, because there was no room to basically make adjustments to this clause. So in conclusion, what I really thought was this judgment actually revealed so much, because what it basically tells us is that the court will more than often really try and enforce what the testator said and wrote in their will that they signed. Because remember, that person's not around now to say, I really meant it this way, or I didn't mean it like that. So the court really has to give value to this person put a signature to this for a reason. Same as if you appoint the wrong executor. It's very hard to have them removed once the testator signed a will to say this will be my executor, because the court according to this case as well, will more than likely really try, and I don't see an issue in it in most cases where the court really wants to honor what the testator signed. The problem is if the testator was a lay person, didn't understand law fully, they can get taken advantage of. And that's where professionals like us and yourselves and through this talk really get in and say, listen, one of the points that I put here in conclusion is that conditions to a will are not always a bad thing. For example, if your estate lacks liquidity and you've got a bond to a property and your son is wealthy, you can say, listen, you can have this property, but please pay off the bond and you inherit the house. That way you free up liquidity, you don't have debt. So you can move with stuff like that. But it always has to be reviewed every year. Because, I mean, with this condition, he could have reviewed it and said, listen, we look at inflation's going to go up, the price is going to go up. So my first point is conditions are not terrible. There's a place for them, but you need to have a professional with you, especially for unique clauses. You have to partner with a professional. You have to make sure that the will is either drafted by a professional or reviewed by a professional. So even if you want to do your own will, you must just at least say, hey, Lisa, Ariana, Dan, can you just look at this for me and tell me if there's anything? First thing that I would have said if I was advising, I'm not charging for this advice. This is a live and this is free. I would have said to them, guys, whenever you do a condition, do a substitute in case of the worst case scenario. So for this one here, I would have definitely said, make sure that the purchase price is market related at a fair price at that time. So the farm at the time, if she dies, it needs to be market related. You also need to consider the inflation and how that changes the price of stuff, because 176,000 to 5.2 million, it's a massive difference. And now all your other kids are sharing on such a small amount when the value is actually worth a lot. So you have to make sure that you put stuff that can make sure that movements can take place, but your wish is still there. So if you were to say the son can purchase it, but don't put a value to it, just say at a price that is acceptable at that time, market related. And I would even chuck in there that the other beneficiaries need to be in agreement with a price that's market related. If there is a dispute, now you even go further, Lisa, because there could be a dispute. Now they could say market value gone for 3 years. You say, if there's a dispute, my executor has the full discretion to make a decision based on evidence presented to him. And his choice then will be final. Then at least you give a bit of wriggle room. If there's a big fight, you say, guys, hold on. Executor now will make a call and you appoint a proper executor. Then you know we're all good.
Yeah.
Cool, guys. So, Ariana, I don't know what your view is on that one first.
Yeah, definitely. Hi, everyone. I'm Ariana. Definitely, I agree. The court isn't there to add in things more than the testator wanted in his will. He could have said it should be a market-related value.
Yes.
He could have added that in, but he didn't. So the court isn't there to add in what was not his intention.
Yeah.
I agree. So it's so important to keep your will updated and account for things like inflation, because the court won't just read that in if it's not contained in the words of the will.
That's good. And Lisa?
Yeah, I think my case has a similar, I guess, principle, one of the principles. But I think what resonates with me is that the fact that it has to be what the testator wants. So in the best case, you're going to ask them to draft it and review.
Yes.
Because the last thing also you want is, maybe one of the children might come back and say, no, but the attorney or the advisor forced her to put this clause in and blah, blah, blah.
Yeah.
So, you want to have it, at least on record that the testator was the one that gave you the initial,
Yes.
and then they've just maybe made changes on advisement, because I think if you had to draft the will for them, I think that might be a whole different story in terms of is it the intention, or is it the intention of the drafter, who's a totally different person.
Yes, exactly. And I think also, like, it's so important that when you are advising a client, if they have a wish in their heart for their estate, even if you might foresee some sort of issue with it, you have to just make sure that whenever you do it, you can provide a solution that they have peace within their heart, and that is their wish and direction. But you're just there to protect in case a future circumstance comes up that they might not be aware of, to say, listen, here's the advice, this could happen and there is a risk of that. What would you like to do given this information? Then you work with them and they say, oh, Daniel, Ariana, Lisa, I didn't see that. Maybe we can try to do this. So you actually, it's quite a nice thing to draft a will with someone that wants to really take care of their family and legacy, because they really give thought to say, like, this is my intention. It's not just throwing it together quickly. And when they engage with people like us, you just really want to honor that and make sure that they are well protected through it. So, do you know what? This was a very interesting case. Even when I was reading it, I was like, sure, just imagine she lived to be 110 and that property was now worth 30 million. Okay. Yeah. And then, I mean, the person will obviously say, hey, I'm going to take loans out and buy this. I can resell it next month for 5.2. So it's so interesting to see how powerful that clause was and how the court said, yes, you can get it for that price. Very interesting.
Yeah. I'm actually glad I guess it's just a nerd in me, but when the cases go to the FCA, I get excited.
Yeah.
Because you're going to get something that's like totally binding, and it's going to be,
and you know what, like,
the decision's going to be shut.
Yeah, and Lisa, like, just like even reading the Supreme Court's ruling, like, I know I'm also a nerd about that, but I love beautiful literature, and just like the way the thoughts are put into paper is so lovely to read. And it's like, I had peace. Like, when you read a court case, like Ariana was saying earlier, you don't know what the outcome's going to be when you're reading the case. Okay, you're reading through the notes, you're seeing, oh, this person fought that. But when the Supreme Court comes in and rules, it's like the way it's written is just beautiful. So I really enjoyed that too.
Yeah, it's so lovely to see their reasoning and the arguments put forth and how they dissect these arguments.
Sure.
Like one little word makes such a difference.
Yeah.
Cool,
Lisa. So on to your case.
So mine, it's the 2014 decision from Gauteng Local Division. I think for me, the reason I chose it is because generally when it comes to legal stuff, I'm big on intention.
Oh, nice.
So I think if you're looking at the drafting of a will, I think maybe even more important than legal, like pleadings and stuff, is like, does this document, the way you're interpreting it, does it reflect the intention of the testator?
Yes.
And also something else I learned as a side note is that the testator and the intention of the drafter and the intention of the testator is also a bit of a side issue, a sub issue, but I think it bears consideration, right? Because here the person who drafted the will was obviously not the testator. So but I mean the tricky thing, like you said, Daniel, is that ultimately you don't want the courts to be pronouncing on the interpretation of your will. So you got to make it, you've got to make it as clear as possible. And in this case, the testator was a very wealthy man, and he had basically a private company and a holding company. And he held shares in the private company via the holding company. But he failed. So in the will, he made a bequest of the shares in the private company, but he failed to distinguish between the holding and the private. So he just put the name of the company, which happened to be the same as the holding and the private. So it was Autocom, right? Autocom Holdings Pty Ltd or Limited, and then Autocom Pty Ltd, something very similar. So he failed to distinguish, or he just put their Autocom. So transfer of shares in Autocom to, or is bequeathing, the shares, and he just put their Autocom. So now, because he's holding shares via the holding company, the way that in terms of which Autocom he was referring to,
Yeah.
had to refer to the situation in which he owned the shares. So the
Yes.
fact that he was doing it via a holding company meant that when he just put Autocom, the shares in Autocom,
Yeah.
it couldn't be him, right? He must have been referring to the holding company.
Yes.
So it just caused a whole lot of confusion because he just left out
Sure.
which Autocom it was,
Yo.
right? So obviously now the applicant is the wife, and I think the respondent was the son, and of course the son wanted to interpret it very widely because he wanted to grab some of his dad's, business fortune, and he
Yes.
made a whole bunch of arguments and, basically trying to ascertain, okay, what was the testator, what was my father, what was the applicant's husband thinking when he put their Autocom, because
Yeah.
he couldn't transfer something he had no ownership in, right?
Exactly.
So the only thing he could have been referring to was the PTY Ltd company, not the Autocom Holdings PTY
Yeah.
Ltd. So the way they had to interpret it, I thought was very, and I think what saved the testator in this case was that he had a testamental clause.
Yes.
So in that testamentary clause, he actually was very specific about in which company he held the shares.
Yeah.
Okay, not in the holding company, but in the private company.
Yeah.
So the court was able to use, and the court was, it was a very clinical, and I can understand the approach of the court because generally in estate disputes, it's a very subjective thing because you've got this story and that story, and usually there's a second or third will that surfaces. In this case, there was another will that surfaced. The son brought up another will. And so the whole inquiry about the intention or what the testator meant could be very easily devolve into a subjective inquiry.
Yeah, and
so
also the testator is not there, Lisa. So it's like the most subjective can be produced because he's not there to advise. I wanted to ask Lisa, who was the beneficiary of that testamentary trust?
It was the trustees. He had a board of trustees.
And who would inherit from that trust eventually? Was it the son or the spouse?
The wife.
Like
the wife, the applicant.
You see, that saved the day.
Yeah.
Because now we're looking now, like what you're saying. So very interesting that you raised that, and I agree with you there.
Definitely.
Yeah. So I think that. Sorry, Ariana.
Sorry. No, that's where the court comes in, and they look at the will as a whole. So the rest of the will was there basically mainly to provide for the surviving spouse, who was the only income beneficiary of the trust that he intended to leave the shares to.
Mm-hmm.
Yeah. So I thought, the fact that the court made that point about this whole thing about what did the testator mean cannot be a subjective inquiry.
Yeah.
It cannot be a subjective inquiry. It has to be an objective one based on extrinsic evidence. So in this case, the testamentary clause.
Yeah.
Or I'm not sure if it was in the will, it was a separate document.
Yeah.
But the court used that and said, okay, objectively speaking, if you take all of the extrinsic evidence into account, what could the testator possibly have meant by just saying, I bequeath my shares in Autocom?
Yeah.
Which Autocom was he referring to? Now, if he didn't own the shares, then obviously logically he's referring to the PTY Ltd because that's a company that he owned.
Yes.
So you got to look at now the testamentary clause or the testamentary document to see, okay, he's bequeathing it to the board of trustees.
Yeah.
And then from there, the court was able to figure out, okay, he wasn't referring to the holding company because that was just a vehicle. He was referring to, the company that he actually owned and which actually sustained the applicant and the testator on a day-to-day basis.
Sure.
So he was getting income from the company that he owned, but not the holding company. It had no bank account. It had no, any of that because it was just an entity, right? Just a commercial entity.
Yeah.
So I thought that it's very difficult. And I think maybe in situations like these, the court needs to come in because it can very easily become a subjective inquiry as to what did mom mean or what did my husband mean or But the court says, okay, we're going to keep this as an objective inquiry. We're going to say, having a look at the testamentary the clause or the document, can we ascertain which autocom the testator was referring to?
Yeah.
The shares in which autocom? Or the board of trustees of PTY Ltd.
Yeah.
So meaning that the shares are to be bequeathed to the trustees of the company that he owns, not the holding company.
Yeah.
So I thought it was a very short judgment, but very, very clinically done.
Yes.
And I think in estate matters, as much as, like you say, we exercise compassion and its legacy, and there's a whole lot of soft stuff to it, which is necessary.
You have to be clinical at times, and also
you have to be clinical.
You being clinical with kindness, because you actually trying to cut out all of the unnecessary debates and discussions. And you know what's quite interesting that I've also noted, Chaz, is that in a lot of worlds as well, there's also the power of interpretation given to the executor. So in a court case like this, I was thinking, would they ask on the executor to say, like, what is your interpretation of this will, and present that as evidence as well? Because remember, the son wants it to be not the business that holds all the stuff, because then it goes into the residue and he inherits. So he's got his agenda that he's going to push. And he's going to say, hey, you left out the word holdings, let's go to court. And it's like,
conveniently.
Guys, yeah, like you said. And also, Lisa, he was a businessman. If he really wanted you to inherit it, he would have put there as a special bequest, my son, this is for you. He wasn't mentioned, he was just in the residue. So why would he as a businessman make such a tricky thing and say, hey, I'm going to leave out a word just so that it can fall into the residue so my wife doesn't get it? You see? So
I mean, he did use that argument, but I think it goes both ways. It shows up the flaw in your argument that he said, oh, my dad was a very astute businessman, and so therefore he knew what he was doing, and he probably did it on purpose so that I could fall into the residue. But clearly, it was for the testator's wife to be protected.
Yes.
And I think the son came in somewhere at the end of that testamentary clause. Like, he was provided for as well. But like, first it was the applicant, which was the testator's wife, that needed protection. And so that argument that he intended it to fall into the residue, that his argument rose and fell on that point, I guess, alone. So. But I think it's just this just a gold digging mentality. That, I mean, like I said, it's a very, very short judgment. And the court captured all of, both sides' argument basis things succinctly. And you could just see, I mean, if I was sitting on the bench, you could just see that he had nothing. He was like pulling on emails and, his external evidence were like old emails and the other will, and the court's like, no, there's a testamentary clause document. This is what your father intended. This is what the testator intended when he just put the autocom and left out the ending. So,
and Lisa, this
very
is
short but very engaging.
And this is also something that we really touch on nowadays, is that if you are a business owner, you need a business succession plan in place that goes along with your will. Because if you're so astute as a businessman, you have to have a plan to say, hey, if I die, I think this person's the best person to take role of my company. I want this person to step in to manage. That wasn't present in this case. But if it was, then we could have said, oh, to the son, you actually have a point here. But because all of that, as well as a business succession plan, wasn't in place, like you said, he was pulling at old emails, little snapshots, and the court, beautifully, just clinical, and just said, hey, guys, let's stop this now.
Absolutely. It was beautiful. It was so clinical. It was.
It was like satisfyingly. It was like, finished. Let's move.
I mean, and the nice part, I guess the nice part of it is that you are allowed to look at external evidence. So as much as, I mean, and yes, executor's interpretation, but if there's external evidence, in close proximity to the will document, not obviously grasping at straws. But if there is external evidence that can help, it is allowed. You are allowed, and the court will conduct that objective inquiry and say, based on those pieces of evidence, this is what the testator meant, or this is the best assessment of what the testator meant. So I mean, external. Yeah. So the fact that you can allow external evidence if you take it to court is, I think it's a nice sort of a space or leeway.
Yeah. And also now, Lisa, do you see the importance of having an independent professional executor? Just imagine, for example, he appointed his spouse as the executor as well, even though she can appoint an agent, and this fight comes out. You see how it becomes tricky. But if you've got someone who doesn't even really connect it to your family bloodline or link, acting as a professional, they've got no interest to favor anyone. They just want to make sure the act is upheld and the requirements are met. So it actually helps provide peace. People are like, hey, if you get a professional in, it's going to cost a fortune. It also costs a fortune if there's a fight and you link to it. And that's
at the end,
not monetary. That's emotional cost, which is way more than 3.5%. So I think also, like, so that's what I'm saying. Like, just have, like, if you want to and you foresee any challenges, especially if you're an astute business person, you've got multiple stuff involved. Just get a professional on as your executor and help them guide you, because you don't want this happening between families afterwards. I mean, this argument over one word, Lisa, just imagine the damage it's done now.
Yes, that's what I was going to add in as well.
Yeah.
That this case shows the importance of language. So one word can make such a big difference, especially with, companies like this, different names and such. I completely agree with the court's logical reasoning here, that it makes no sense for the testator to have bequeathed something here that he didn't own. So they have to look at the will as a whole.
Yeah.
Yeah.
A very, very interesting case. Thank you, Lisa. Thank you so much for sharing that case. We could actually talk about this for the whole day. And I mean, we could even just read the literature for the whole day. But very good case. And I think the two cases we've had and started with, I really like the interpretation and how you have to look at it if there's a bit of a conflict in it. And you have to really, there's the concept that Ariana showed me. It's called the armchair view. And it's basically a principle that you have to sit in that person's seat when he signed that will or she signed that will. What do they really mean by this? You're not yourself now, you're in their armchair. And you have to look at it from that eye. And it's almost like, you can't teleport in real life. But we can have fun and teleport and say, hey, we're in his position now. What was he thinking when he did this? And also remember, like I said, if he wanted to really give it to his son at that stage, he could have put reference numbers to the companies, the registration numbers in there, specific. So very interesting, Lisa. Thank you so much for sharing that. And then Ariana is going to share on her one now.
So I'm going to be talking about a case that deals with one of the legal requirements for a will to be valid. I'm speaking about Kidwell versus the Master, which is quite an older case. It's 1985. So I thought that would be interesting to look at what's changed since this judgment and how we can apply this. So in this case, the testator signed 13 centimeters below where the witnesses had signed in a will. So this is significant. It's quite a large gap, maybe half a page or so, almost half a page from the end of where the witnesses had signed his will as well. So in this case, it was held that the will was invalid because the testator had signed so much below the end of the writing of the will. So this is significant because in the Wills Act, it says that the testator needs to sign at the end of his will. It's a bit confusing, you see, it's open to interpretation because the Wills Act doesn't define where the end is.
Where's the end,
says the testator must sign at the end thereof. So then, in this case, obviously it was determined that the will was invalid, and scholars agree now that a will should be signed at the end of the writing as much as possible. But commentators also disagree with this judgment because they say it was too strict. where they said that the will was invalid now, even though the testator intended that document to be his will because he signed it.
Yeah. The intention part again.
Exactly.
That's quite cool.
Intention always comes up when it comes to wills.
Yeah.
So then also comment to say that, the courts should give effect to the wishes of the testator, not look at the overly formal aspects of the legal requirements. So since this case was heard, there has been an amendment to the Wills Act, which is the rescue provision, which is section 2(3) of the Wills Act. So now other commentators have also said that if the situation comes to court again, the court likely will accept that will if it meets the other requirements of that section.
Yeah.
As if it shows that was the testator's intention.
Yeah.
To have that as his will. Yeah. So basically the courts say now that you shouldn't try to frustrate the testator's intention. You should try to give effect to the provisions as much as possible.
Yo, that's nice.
Yeah.
That's
I like
really cool.
I like how all the cases are just, we chose them randomly, but they all they all coming together, this intention thing.
And you know what's cool as well is that like the evolution of this. They say that the act hasn't been updated, but the law has evolved, and that's what's beautiful. Is like yes, it states in the act that shortly after the writing you must sign. So someone signed 13 centimeters below, and they say, it's not acceptable. But now the debate starts. Okay, it's his original wet ink signature. Why are we being overly formal with this? Let's look at the intention, which is what you said you also value so much.
Yeah, which is he wanted to sign the will, and he signed it.
Yes,
in keeping with the requirements.
He signed on that piece of paper.
Oh, he didn't put PTO and then signed on the other side.
Yeah, or be right back with the initial. I mean, he signed it, but just imagine that family when they said, no, this will isn't allowed because you signed 13 centimeters under. The family now, just imagine.
I mean, just from a layperson's perspective, it's frustrating. Because they'll say, hey, look, there's my father's signature, or there's my mother's signature, or there's my husband or wife.
Yes.
It's on the same page after the witnesses, so that's the end of the will.
Yes.
Or on that page is the end of the will.
In this case, the Wills Act doesn't define where the end is.
Where the end is.
The end. So that could also be changed in the future, perhaps. Maybe that's something.
It could be the end of the page.
Yes.
The end of
the page, the last little corner of the right angle corner of the page. That's the end of the page. So he could squeeze it in there, right till the edge, provided it's complete enough, and that's the signature at the end of the page. So I think it's a circular argument there, because they're saying it doesn't comply because it's not at the end of the page, but the Wills Act at that time didn't define what is the end of the page.
What centimeters are you talking about?
Yeah, so
the Wills Act still doesn't define where the end of the page is.
So it kind of goes in circles. So you're saying it's non-compliant in terms of what? If the Wills Act doesn't say where the end is or how many centimeters below is acceptable, then you can't rely on the Act.
Yes.
So the court's reasoning there was a bit faulty.
And also remember, Lisa, okay, so they said 13 centimeters isn't acceptable. They didn't say it must be 10. So they left us now. So what happens if we do 12 and then 11 and 10? So you see, they didn't give proper guidance on that. But I was just thinking now, do you know what's quite important? Is you need to also maybe have a contact reference for the witnesses, because they could have been called and said, listen, can you do an affidavit to say that he was there and he signed it and he meant to sign it? Because back then, this was disallowed, which is a massive problem. It's only after reflection that we say, hey, come on, guys. Because we now all start to support that family, but it's too late because that estate's been finished. And it had to have been obviously interstate if there was no other wills.
I think the witnesses are really undervalued. I think, as much as we'll say, okay, it's 2 witnesses, the same 2 on every page, and blah blah blah. But in terms of when there's a dispute, how can they be called upon?
Yes.
To to vouch for anything, to vouch for the fact that the testator was there and signed, or any other aspect, legality of the will.
Yeah.
What's the role? What's the role of the witness going to be? So, like you're saying, in this case,
Yeah.
there could have been some, please say that, because as long as it was the testator, I mean, if somebody else signed for the
It's
testator
a
at the
big
end of the
problem. Yeah.
page,
Yeah.
then there's a problem.
Yeah.
But you can strengthen your
Yeah.
case by saying, calling on the witnesses and saying, it was him who signed at the end of the page. We saw it.
Yes.
So
and
what
it's
more
his
can
will.
you say to shoot it out the water? You
Yeah.
can't.
And you get 2 affidavits from the witnesses, and you lodge that with the court, and you say, guys, come on, the witnesses have confirmed under commission that it was him.
Yeah.
And then you get a handwriting affidavit from the family to say, this is my father's signature. You lodge that. The court then can't say, guys, come on, it's 13 centimeters, we're not allowing it. Because then we would all be in trouble.
I mean, I'm curious. Ariana, did what was the reasoning of the people that were holding that it was, were arguing against the validity? I mean, if the act doesn't say the end is,
Yeah, who
wherever it
viewed
might
that it
be,
was
what
invalid?
was the, because I mean, the fact that, because obviously the court went with one of the sides,
Yeah.
and
Yes.
to me, if I was sitting on the bench again, it's a very circular argument because I'm basing it on the act, but the act itself doesn't say where the end is. So, like,
You can't be firm
where's
in
the
that.
where's the strength of that particular argument? Like, I'll be interested to know, like, how the court kind of reasoned that out, because it just seems to be like, you're
So
going
I
in
think,
circles.
I think at that time, the legal perspective was a lot stricter, often in cases, was more legal in the sense of sticking to the exact words and the literal meaning of things. They didn't interpret it in the testator's favor as much as they do, now, leaning the intention of the testator, as is the trend now. We've seen
That's
in
the
all of our
evolution.
cases. Yes.
Yeah.
So what the court actually said here was, the conclusion to which I have come is unfortunate and may frustrate the testator's intention. They admitted that in the case,
Yo.
but they still went ahead with it. But
What?
now, as we've seen in our cases, the trend which has developed.
It's beautiful, the new trend.
Exactly,
Yes.
is to look at the testator's intention and all the external evidence as well.
Yeah.
Of the testator's
Yeah.
intention, and not just
Yeah,
go
even in the one that I did, they made mention of that presumption that even if it's hard, if it's what they call latent and patent ambiguity,
Yeah.
even if either one of those are present, there is that presumption about that the testator meant well,
Yes.
or it was a benevolent meaning, as opposed to being deliberately obtuse, or so you're not going to frustrate. So that whatever interpretation the court gives is not going to frustrate the intention of the testator in that particular clause, or in leaving out a word or whatever. So I think the fact that they acknowledge that they are frustrating is epic. I mean,
Yeah.
the fact that the court has to deal with a personal document like a will is one story.
Yes.
But the fact that it's coming to court, and in the court ruling, the court is admitting that they are so then what's the purpose of the will?
Yes.
Yes.
What's the purpose of the will? You might as well throw the entire thing out, and the court decides what the will is on behalf of the testator. Because, I mean, it's just, you have to give the best, elevation. You have to give the best interpretation to what you think the testator meant. And you have to interpret it in a good way, in the best way that you possibly can, with all of the extrinsic evidence. You cannot assume that the testator meant the worst, or meant badly, or meant to defraud, or make the will subsequently invalid. You can't interpret it like that. Then there's no point in having the will.
It's so nice to see that the law has been updated since then. With the amendment to the Wills Act,
very much so.
Section 2.3, which is the rescue provision. So this provision basically says Now, if you have a will that the court determines was intended by the testator to be his will, you can apply to court for them to order the master to accept that document as a will if it meets
Yeah.
certain requirements. So there is that allowance now.
But you know what? Also, like from my side and from our team side, if we were to have a similar, because it also depends whose desk it lands on that's going to say this is an issue, okay, with the will, we're not accepting it.
Yeah.
Okay, us as the professionals, the first thing we do, like you mentioned, we get the witnesses to sign an affidavit to say that they confirmed that it was his signature, it was his thing. We get the family to say we confirm it's his signature. Then we put a proposal to say, listen, we've got the evidence, we've done work to show you that because remember, if the witnesses say to us, we're not going to sign an affidavit, then we can say, okay, cool, well, then the court might have a point. But if the witnesses come and say, hey, guys, we're going to sign this, he was here, it was his will, and then we present that to the court, we might not have to go to a judgment. We can debate about it, and then they might see, oh, they've actually done work to show me what happened here. I'm going to change this in a sense. So your executor can also play a massive role in helping mitigate further action like this, because maybe the executor said, okay, fine, I accept. And then that's why it had to go to a whole thing. But I would strongly, like you said, if this were to happen to you, Lisa, as an executor, and the court said, hey, your client signed the will 13 centimeters under the witness, your brain's going to start to think, no, I'm not going to accept this. Please don't. And then you start your case, but you don't just say, okay, cool, we'll do interstate. You have to also defend.
Oh, yeah.
But like you said, it's so funny that they said, hey, frustrating the testator. You don't want to frustrate anyone.
No, that document is not a court document to start off with.
Yes.
So you shouldn't even be pronouncing too heavily on it, because you don't have that latitude. You don't have that maybe the executor can do that, but you don't have, as a court, you don't have any latitude over a document like a will, which is by nature extremely restrictive.
Yeah.
And set in stone. So you shouldn't be frustrating anything in terms of that document. Pleadings, affidavits, fine, that's your domain. But the will, no, you should be giving the fullest intention. And I'm also very relieved that the courts have changed. That we have that presumption now that the testator meant well. You interpret it in the best possible light. Otherwise, every will, it'll be an entirely litigious.
Yes.
And, just insensitive.
It's indefensible because the testator is not here. So like you said,
he's not here.
You have to have the best. There will be people who take advantage of it, but that's the same for anything. But if you have their best intention and heart, and you dig and you find out, oh, there was foul play, you reveal it. But you don't just automatically assume because he signed 13 centimeters, it wasn't really his thing. So,
I mean, who aims to deliberately make your will invalid?
Yes.
Why do the will in the first place if you want?
Yes.
Also, Lisa, I think the court didn't fully take into account here the nature of the testator as a layperson who doesn't have access to the law or to see that you have to sign at the end of the writing, or didn't know the practice that it's the common thing for people to sign at the end of the writing, at the end of the page.
I mean, and as his or her attorney probably said, just sign below the witnesses, and that could be anywhere.
Do you know
so
what's interesting, Lisa? I was getting my hair cut, and I told my hairdresser about this case. She said, Daniel, the first thing I'm checking is where I sign my will. Because now you're going to measure. Because Lisa, you don't want to go to court to prove, hey, I signed 12 centimeters. You just want it to be accepted. So, to be super safe, sign under the writing. But, that's also the first thing that someone would think, it's just a bit too low. Let's keep it within 10 centimeters. It's the fact that they reference a centimeter difference, 13.
I mean, just on a slightly humorous note, I probably would have done that thing pro bono.
Yeah.
I'd be like, no, if you want to fight about this, I'm not going to charge for it.
Yes. let's see where it
There
goes.
shouldn't be a fight.
Yeah.
Yeah.
But I think this has been a very, very interesting discussion. Like you said, we picked these cases completely randomly, but it's beautiful to see the threads that come through with all the cases. And I hope that the listeners will learn from this and benefit from our discussion today. Lisa, I told Ariana that I literally want to do lives with you forever. So even if we just do like 1 or 2 a year going forward, I really enjoy our conversations, and I think that a lot of people are benefiting from it.
Yeah.
And that's the beauty of this social media setup. They can be anywhere in the world and they can just jump on and learn from what we're talking about.
Yeah. Yeah. I mean, I don't even come onto Instagram except for these.
Yes, but you're growing a following on Instagram.
Totally by accident. Totally by accident.
Yeah, but thank you so much, Lisa, for your time. We really appreciate it. Thank you, Ariana, for your time. Guys, just quickly, the giveaway. When we load the video, all you have to do is comment where you are listening to the live from, and we'll pick 2 random winners and post these books to you. Thank you, guys. Lisa, have a lovely day. Ariana, thank you. And bye, everyone.
Thank you.
Cheers.
Bye.